In this video, I'm going to talk about the procedural safeguards of Article 6 of the European Court of the Human Rights and its applicability on civil rights and obligation, as well as some possible examples of the proceedings on the failing under Article 6, and a little explanation on the hindrance of the applicant's rights and the importance that there is on the national law provisions which might apply on these situations. So the article says reads a little bit as follows: that in the determination of the civil rights and obligations or of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. The judgment shall be pronounced publicly by the press, and public might be excluded from all or part of the trial in the interest of moral, public order, or national security in a democratic society, where the interest of juveniles or the protection of the private life of the parties so require, or the extent strictly necessary in the opinion of the court in special circumstances where publicity would prejudice the interest of justice. So everyone charged with a criminal offense shall be presumed innocent until proven guilty according to law, and everyone charged with a criminal offense has the following minimum rights, which is to be informed promptly in a language which he understands and in detail of the nature and cause of the accusation against him, and to have an adequate time and the facilities for the preparation of his defense, to defend himself in person or through legal assistance of his own choosing, or if he has not sufficient means to pay for legal assistance, to be given it free when the interest of justice so requires, and also to examine or have examined witnesses against him and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. And finally, to have the free assistance of an interpreter if he cannot understand or speak the language used in court. So the right to access to a court for the purposes of Article 6. In this video, I'm going to focus on the right to access to a court and on the quality of legal assistance. So as I was saying, the right of access to a court for the purposes of the Article 6 was defined on the first time in Golder versus the United Kingdom, and it was referring to the principle of the rule of law and the avoidance of the arbitrary power which underlied on the convention. The court held that the right of access to a court was an inherent aspect of the safeguards enshrined in the Article 6, and the refusal of a court to examine allegations by individuals concerning the compatibility of a particular procedure with the fundamental procedural safeguards of a fair trial restricts their access to court. It means that the court should be accessible, involves availability of courts with relevant jurisdictions, availability of interpretation, access to information, and accessibility to court judgments. Now I am going to approach the right of access to a court. For example, in the case that I just mentioned, which is Golder versus the United Kingdom, the applicant was a prisoner who wanted to bring libel proceedings against a prison officer who accused him of taking part in a prison riot. He was refused permission to consult a lawyer, which he claimed hindered him in bringing an action in the courts. The European Court of the Human Rights held that the Article 6 sets out the procedural guarantees available to parties in a litigation. This will be meaningless without access to court. Thus, the right of access to a court is implied in the right to a fair trial under Article 6, number 1 of the European Court of the Human Rights. In this case, what happened is that inside the prison, they had some rules made by the Home Secretary and the exercise of this power. They were the prison rules number 1964, and this was a relevant provisions concerning communication between prisoners and persons outside the prison. So therefore, they had these rules inside the prison that they used to prohibit him to get into contact with his lawyer. Now, under the European Court of Human Rights, must be effective, practical, and effective, rather than theoretical and illusory. For the right of access to a court to be effective, states might have to provide legal aid, translation, or other practical support to enable individuals to access to court proceedings. So even if this law that they had inside of the prison, it was a violation to this right. The quality of legal assistance, which is the second example and the second subject that I'm going to focus on concerning this article, the right to a legal assistant is a right to effective assistance and representation. The presence of a lawyer who has no opportunity to intervene to ensure respect for the accused or suspected person rights is of no benefit to the accused or suspected person. For example, in Aras versus Turkey number 2, the applicant was arrested on suspicion of aggravated fraud. He was questioned without a lawyer by the police and made statements in connection with the offense. He was then brought before the public prosecutor where, without a lawyer present, the applicant repeated his police statement. When the applicant was brought before the investigation judge, the judge allowed the applicant's lawyer to enter the hearing room, but he was not allowed to take the floor or advise the applicant. The European Court of Human Rights stated that the mere presence of the lawyer was not sufficient to make effective the right under Article 6, number 3, paragraph C. The applicant should have had access to a lawyer from the first questioning. The applicant's lawyer passive presence in the hearing room could not be considered to be insufficient by the European Court of Human Rights standards. How to conduct the defense is essentially a matter between the accused or suspected person and his or her lawyer. But if relevant authorities are alerted to a manifest shortcoming on the part of the lawyer, they should act. This obligation arises only where the failure to provide effective representation was manifest or sufficiently brought to the state's attention. For example, when an appeal is deemed inadmissible due to a lawyer's omissions, this might violate the right to a practical and effective defense. Only shortcomings imputable to state authorities can give rise to a violation of Article 6, number 3. For example, state liability may arise where a state is aware that a lawyer has failed to act for the accused. However, even serious shortcomings in the fairness of proceedings might not give rise to a violation if the applicant fails to raise the issue on appeal. Under European law, the directive on the right of access to a lawyer confirms that a suspect or an accused person have the right for his or her lawyer to be present and participate effectively. The lawyer's participation must be in accordance with procedures under national law, provided that such procedures do not prejudice the effective exercise and essence of the right concerned. Thank you very much.